In 12 Nigerian states, a woman can be sentenced to death by stoning legally, not in secret, not by a mob, by a court, with a judge, with paperwork. And here's what nobody is asking. While Nigeria's constitution guarantees every citizen equal rights regardless of sex or religion, those same courts have been operating for over 20 years, sentencing women to punishments that would be considered torture under international law. So the question isn't whether Sharia law is right or wrong. The real question is this: who gave these courts the power to override the Nigerian constitution, and why has Abuja let them do it for 2 decades without a single definitive legal challenge? Stay with me, because the answer involves money, politics, and a deal that was made in 1999 that most Nigerians still don't fully understand. Before we go deeper, if you're just finding Nigerian news feed, welcome. This channel exists to break down what's really happening in Nigerian politics without the noise, without the spin. Hit subscribe and stay with me, because this one gets interesting. Let's set the foundation. In 1999, when Nigeria transitioned from military rule back to democracy, something significant happened in the north. Zamfara State, under Governor Ahmed Sani Yerima, became the first state to formally adopt Sharia criminal law. Within 2 years, 11 more northern states followed: Kano, Katsina, Sokoto, Kebbi, Naija, Jigawa, Yobe, Borno, Bauchi, Gombe, and Kaduna. Now, Sharia law in Nigeria isn't new. Islamic personal law, covering marriage, inheritance, divorce, had existed in the north for generations under colonial and post-colonial arrangements. What was new in 1999 was the extension into criminal law. Hudud punishments, which include amputation for theft, flogging for alcohol consumption, and stoning to death for adultery, became legally codified in these states. The trigger for today's conversation is a series of recent cases that have reignited debate across Nigeria and internationally. Women, predominantly poor, predominantly rural, have been hauled before Sharia courts on charges of zina, which is unlawful sexual intercourse. Some have been sentenced to death by stoning, and a growing network of Nigerian women's rights lawyers and activists are now doing something unprecedented. They are taking these cases to federal courts and arguing that the sentences are unconstitutional. This isn't just a religious story. This is a constitutional crisis that has been slow burning for 25 years, and it may be reaching a tipping point. But to understand why these women are losing or winning, we need to understand the legal architecture that allows this to exist at all. Here's where it gets complicated, and deliberately so. Nigeria's 1999 constitution is very clear in Section 10. Nigeria shall not adopt any religion as a state religion. Section 38 guarantees freedom of religion, and Section 34 guarantees every person's right to dignity, explicitly prohibiting torture, inhumane or degrading treatment. So how are these courts legal? The answer is Section 277 of the same constitution, which gives state government the authority to establish Sharia courts of appeal to hear personal law matters for Muslims who voluntarily submit to that jurisdiction. Here's the gray area that was weaponized: the word personal. In 1999, when northern governors adopted full Sharia criminal codes, they essentially argued that criminal law could also fall under state jurisdiction, and that Muslims in their states were voluntarily subject to it simply by virtue of being Muslim and living there. The federal government, under President Obasanjo at the time, chose not to challenge this directly. Why? We'll get to that. The institutions involved are the state Sharia courts at the trial level, state Sharia courts of appeal, the Federal Court of Appeal, and ultimately the Supreme Court of Nigeria, which has never delivered a definitive ruling on whether Sharia criminal law is constitutional. That absence of a Supreme Court ruling is not an accident, it is a choice, and it has left a legal vacuum where women, in particular, are the ones paying the price. The specific vulnerability is this: women accused of zina, adultery, or fornication are frequently convicted on the basis of pregnancy outside of marriage as automatic evidence of guilt. Men, meanwhile, require 4 male witnesses to be convicted of the same offense. That asymmetry alone is a constitutional gender discrimination argument waiting to be made at the highest level. And here's the part that should make you stop. Some of the most prominent defenders of these courts are not clerics. They are elected politicians who have never set foot in a Sharia court in their lives.
This is the section that changes everything. Pay attention. Why did Obasanjo not challenge the Sharia expansion in 1999? Because he needed the North to survive politically. Obasanjo, a Yoruba Christian from the southwest, had just been handed the presidency by a military establishment that was predominantly northern. His legitimacy in the north was already fragile. Challenging Sharia adoption would have been interpreted as a southern Christian president attacking northern Muslim identity. It would have fractured the PDP coalition before it even had a chance to govern. So, a bargain was struck, not in writing, not publicly, but a functional political bargain. The North gets Sharia, Abuja doesn't interfere, and everyone continues to share the oil money from the South. That bargain has held under every administration since. Who benefits from maintaining the status quo? First, northern governors and political elites. Sharia adoption in 1999 was in part a political mobilization tool. It created an identity-based constituency that could be reliably activated at election time. A governor who defends Sharia is a governor who can claim to be defending Islam, culture, and northern identity simultaneously. That's a powerful political asset. Second, religious establishment figures, the ulama, the Islamic scholars, who have gained institutional authority and influence within the Sharia court system. Their power is directly tied to the continuation of these courts. Third, certain federal politicians who use the Sharia question as a bargaining chip in national coalition negotiations. When you need northern votes, you don't touch Sharia. That's the unspoken rule. Who loses? The most obvious losers are women, particularly poor, rural, uneducated women who have no access to legal representation and no understanding of their constitutional rights. These are the women appearing before Sharia courts. These are the women being sentenced. But there are other losers too. Christian minorities in northern states live with the anxiety of being governed under a legal framework that explicitly privileges one religion. Moderate Muslims who do not want criminal Sharia but feel unable to say so publicly are silenced by the political dominance of those who do. Foreign investors quietly note the legal instability and factor it into their risk calculations for operating in the north. The women fighting back, who are they? Here's where the story becomes genuinely remarkable. A network of Nigerian female lawyers, many of them Muslim, have been building a legal strategy for years. Organizations like Baobab for Women's Human Rights and the Women's Rights Advancement and Protection Alternative, RAPA, have been providing legal representation to women facing Sharia court sentences. Their argument is not anti-Islam. Their argument is constitutional, that the Nigerian state cannot execute a citizen, regardless of religion, through a process that violates federal due process guarantees. The most famous early case was that of Amina Lawal in 2002, sentenced to death by stoning for adultery after giving birth outside of marriage. Her conviction was eventually overturned on procedural grounds by a Sharia appellate court, not because stoning was ruled unconstitutional, but because proper Islamic legal procedure had not been followed. The federal constitutional question was never resolved. That is the legal gap these women's rights lawyers are now trying to close. The electoral dimension. With the 2027 elections beginning to shape up, this issue has become politically sensitive again. Any politician who openly endorses full constitutional challenge to Sharia criminal law risks losing northern Muslim votes.
Any politician who stays silent is complicit in a system that sentences women to death for consensual sex. That's the political trap, and nobody in Aso Rock wants to spring it. There is one player in this story I haven't mentioned yet, one institution with the power to resolve this once and for all that has been completely silent. We'll get there. Now, if what I just laid out surprises you, drop a comment below. I want to know your take before we get to the part that changes the whole picture. Let's zoom out and think about what this means for Nigeria as a whole. Federalism under stress. Nigeria's federal structure is built on the idea that states have autonomy within constitutional limits. But when states operate criminal justice systems that potentially contradict federal constitutional guarantees, you have a federalism problem. The fact that this contradiction has existed unresolved for 25 years tells you something important. Nigeria's federal government has consistently chosen political stability over constitutional clarity. The question is how long that trade-off can hold. Economic consequences. The 12 Sharia states are not Nigeria's economic powerhouses, but they are home to roughly half of Nigeria's population. Chronic underinvestment, insecurity, and legal uncertainty in the north have contributed to a widening north-south economic gap. When businesses, domestic or foreign, evaluate operating environments, legal unpredictability is a red flag. A state where the criminal legal system is of contested constitutional validity is a state where contract enforcement and property rights feel less certain. Social cohesion. Nigeria has navigated religious tension before, sometimes badly, sometimes with remarkable resilience, but the Sharia question creates a structural fault line. When northern Christian minorities feel they exist outside of the protection of their own constitution, and when southern Nigerians see a two-tier justice system based on religion, the social contract frays. Security. This is perhaps the most underappreciated dimension. Boko Haram's original ideological argument, before it became a full insurgency, was that secular governance was incompatible with Islam. The existence of Sharia criminal courts in the north does not prevent extremism. In fact, some analysts argue it creates a competitive pressure. If mainstream Sharia courts are seen as corrupt or compromised, more radical interpretations fill the vacuum. The women challenging these courts are, in a very real sense, also arguing for a version of the North that is less vulnerable to that extremist narrative. Here's the counterintuitive point. Some of the strongest support for these women's legal challenges is coming from Muslim scholars inside Nigeria who believe the current Sharia courts are a distortion of genuine Islamic jurisprudence, not a faithful representation of it.
There is a genuine international dimension here, so let's cover it briefly. The Human Rights Framework. Nigeria is a signatory to the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, and the African Charter on Human and People's Rights. Both frameworks are incompatible with stoning sentences and with a legal standard of proof that is inherently gender discriminatory. International human rights bodies have documented these cases and issued statements. But international pressure has had limited practical effect, partly because Nigeria responds to these criticisms by invoking sovereignty and religious freedom. The UK and US position. Both governments have, at various points, raised concerns through diplomatic channels, particularly when high-profile cases like Amina Lawal attracted international attention. But neither government has made this a central diplomatic priority with Nigeria, for the obvious reason that Nigeria is too strategically important in terms of oil, regional security, and counter-terrorism cooperation to risk over a domestic legal dispute. The diaspora dimension. For Nigerians in the UK, US, and Canada, this issue cuts in complex ways. Many diaspora Nigerians are uncomfortable with both extremes. They don't want to be seen as attacking Northern Muslim identity, but they also cannot defend stoning as a legal punishment. The women's rights lawyers have been effective at framing this not as a religious debate, but as a constitutional and democratic one, and that framing travels better internationally. The global pattern. This isn't unique to Nigeria. Countries from Malaysia to Pakistan to Sudan have navigated versions of this tension between constitutional secular frameworks and Islamic criminal law. In almost every case, the resolution, when it comes through domestic legal challenge, not international pressure. That's actually an argument for optimism about the Nigerian women's legal strategy. Let me still man the opposing position before I break it down. The strongest argument for Sharia criminal law in the North. Muslims in these states argue, not unreasonably, that they voted for governors who promised Sharia implementation, that this represents a democratic expression of community values, and that the Nigerian constitution's guarantee of religious freedom should extend to Muslims wishing to live under the full scope of their religious law. They also argue that Western criticism of Sharia is often hypocritical, coming from countries with their own histories of unjust legal systems. These are not frivolous arguments. The democratic legitimacy point in particular deserves to be taken seriously. Where it falls apart. Democracy is not simply majority preference. Constitutional democracy means that certain rights, including the right not to be executed, cannot be voted away even by a majority. The Nigerian constitution is explicit on this. A state government cannot legislate a person to death through a process that the federal constitution does not sanction. That's not a Western imposition, that's the constitution that northern politicians themselves took an oath to uphold. Furthermore, the evidence consistently shows that Sharia criminal sentences fall disproportionately on the poor, the female, and the politically unconnected. Wealthy men in these states are not being stoned. They are hiring lawyers. That's not Islamic justice. That's class-based selective enforcement wrapped in religious legitimacy. Common misconceptions. 1. This is purely a religious issue and outsiders should stay out. No, it is a constitutional issue. When a Nigerian citizen is sentenced to death, every Nigerian has a stake. 2. The women challenging these courts are anti-Islam. The most prominent lawyers in this space are Muslim women arguing from within Islamic legal tradition as well as from the Nigerian constitution. 3. Nothing will change because the North will never accept it. History says otherwise. Legal change on sensitive issues often happens gradually through appellate courts, through procedural rulings, through attrition, not through dramatic overnight reversals. That institution I mentioned, the one with the power to resolve this permanently, it's the Supreme Court of Nigeria. And the reason it hasn't is because no case has been structured and argued in a way that forces it to. The current generation of women's rights lawyers believe they are close to building that case.
Most likely next moves. The Women's Rights Legal Network will continue to build cases that are specifically designed to reach the Supreme Court with a clean constitutional question, not a procedural escape route like the Amina Lawal case, but a direct challenge to whether Sharia criminal stoning sentences are compatible with the 1999 Constitution. This is a long game. It may take another 5 to 10 years, but the infrastructure for that challenge is being built now. Northern governors will continue to maintain Sharia criminal codes on the books, while quietly allowing enforcement to be inconsistent. Political theater for the base, practical flexibility in reality. The federal government under Tinubu will almost certainly avoid this issue entirely ahead of 2027. There is no political upside for Abuja in engaging it. Watch for these signals.
If a Sharia court sentence is appealed all the way to the Federal Court of Appeal and a ruling is made, that's a significant escalation. Watch which way that court rules and whether Abuja responds. If international attention spikes around a specific case, as it did with Amina Lawal, watch whether northern governors try to resolve it quietly at the appellate level to avoid the pressure, as they did in 2002. If moderate northern Muslim voices begin to publicly support constitutional limits on Sharia criminal sentencing, that's a genuine shift in the political landscape. Best case scenario: a Federal Court of Appeal or Supreme Court ruling establishes that Sharia criminal hudud sentences require federal due process standards, effectively neutering the most extreme punishments while leaving personal law intact. Northern political elites accept this as a face-saving compromise. Women gain a constitutional floor of protection. Worst-case scenario: a high-profile stoning sentence is carried out. International outcry follows. Nigeria's diplomatic relationships suffer. Northern hardliners use the international pressure as evidence of external attack on Islam. Radicalization increases. The federal government remains paralyzed. Long-term impact if nothing changes. The legal ambiguity continues to be exploited against the most vulnerable. The North-South constitutional divide deepens. Nigeria limps forward with a federalism that works differently for different citizens depending on where they were born and what religion they practice, which is not a constitution, it's a fiction. The women at the center of these cases are not activists by background. Most of them are farmers, traders, domestic workers. They didn't go looking for a constitutional crisis. The constitutional crisis found them. Let's come back to where we started. I asked you, who gave these courts the power to override the Nigerian constitution, and why has Abuja allowed it for 2 decades? Here's the answer. Nobody explicitly gave them that power. They took it in a moment of democratic transition when Abuja was too politically fragile to say no. And every administration since has inherited that fragility and made the same choice: silence over clarity, political stability over constitutional integrity. The women challenging these courts are not asking for the North to abandon its faith. They are asking for their country's constitution to mean something. They are asking that being born female and being born poor should not make you more likely to die at the hands of a legal system that was never designed to protect you. That's not a religious question. That's a Nigerian question. And how Nigeria answers it will say something important about what kind of country it wants to be. What's your take? Do you think the Supreme Court will ever rule on this directly? Or is this one of those questions Nigerian politics will never allow to be cleanly answered? Tell me in the comments. If this breakdown gave you clarity on what's really going on, do me a favor. Share it with one person who needs to understand this. Like the video, subscribe to Naija News feed, and I'll see you in the next one. Stay sharp.